Good afternoon. My name is Rob Patchett. I am Chair of the Administrative Law Section and Board Attorney for the North Carolina Medical Board. It is an honor and a pleasure to moderate the first installment of Rules of the Road, a lunch and learn opportunity for administrative lawyers, paralegals, staff, and rulemaking coordinators to gain valuable knowledge and tips from experts in the field, such as our panel today, Ann Wall and Anna Choi. Today, they'll be covering the existing rules review process. This will include why understanding the existing rules review process is important, a brief overview of the process, the negotiation with RRC staff of your readoption deadlines, practice tips and things to consider in deciding on the deadlines that you want, and a brief mention of exemptions. Rules of the Road is one of the many fantastic benefits of being a member of the Administrative Law Section. We hold 2 CLEs, one in the fall and one in the spring, which provide content and resources on administrative law that you will not find anywhere else. As a member of the section, you'll have access to a tremendous network of practitioners who are eager to engage and advance the practice of administrative law. If you're not a member, you're missing out. And it's not just for attorneys and paralegals. There's an affiliate membership option for non-lawyers to join our section. Head over to ncbar.org for more information. A few housekeeping items. This session is being recorded. The Bar Association will upload this recording to the YouTube channel and provide a link. Please keep your microphones muted. If you have a question, please use the chat box to pose that question. I'll be monitoring the chat and we'll save all of the questions for the end during a Q&A period. However, if it seems that there's a lot of questions about a particular topic, I will use my power as moderator to jump in and pose a question. Our next Rules of the Road will be Friday, August 8th, and our goal will be to host a session every other month. We'll be sending out a survey at the end of this session to get feedback on whether you like the content, what you'd like to hear in the future. This series is for you, so please fill out that survey and let us know what you want to know about rulemaking. Now I'd like to introduce our esteemed panel. Anna Baird Choi is a former chair of the Administrative Law Section and has practiced law in Raleigh for 31 years, working in both the private and government sectors. In the past few years, she has represented numerous occupational licensing boards in a variety of matters, including rulemaking. She also served on the North Carolina Rules Review Committee for 8 years. Currently, Anna is the General Counsel of the North Carolina Licensing Board for General Contractors, where she also serves as the board's rulemaking coordinator. Ann Wall is a former chair of the Administrative Law Section who has practiced law for 47 years as a public servant with state and federal government. She drafted her first rule while doing a work study with the Department of Labor and Law School and later handled rulemaking for the department. She litigated while in DOJ on behalf of an HHS division. She is the General Counsel and Rulemaking Coordinator for the Department of the Secretary of State. Ann and Anna, take it away.
Thanks, Rob. Well, welcome, everybody. I think when the admin law section was talking about little lunch and learns, I think we were trying to figure out what is the most exciting, interesting, and thrilling topic in state government. And of course, it's got to be rulemaking, right, Ann?
Absolutely.
So I think one of the reasons that we wanted to talk about this, or that we felt that it was important, of course, not only to our agencies and for those of you in private practice, your clients, is that we've all been through a periodic review process, but this one's a little bit different. And I would say not by much, but there are some significant differences, and not just the removal of what we used to lovingly refer to as that middle bucket. And so, as we start out today, we really wanted to, Ann and I hope that we will help you understand why the periodic review and expiration of existing rules process is important to understand. And I think one of the main things to understand is if you aren't careful, you're going to lose a rule. And it might be some rules you might be happy to lose, but others, it might be a very important rule that's very significant, not only to your regulated public, but to the citizens of North Carolina. So I think that's sort of the overarching thought that I would want to leave you with is it's very important because you're likely to lose the rule. Those of you, if you don't follow the process, Those of you who participate in rulemaking a lot know that rules review has the ability, if they choose, to give extensions or to vary requirements based on their rules. But I think it's really, really important for everyone to understand, especially those that don't do rulemaking frequently, is that is not a discretion, a power that the Rules Review Commission for quite some time um, exercises on a regular basis. In other words, they will grant extensions, what I would say sparingly, if at all. So it's really important when you're looking at the process and you're looking at deadlines to build in cushions for yourselves, for your agencies, recognizing that meetings may not take place when they're scheduled. There may be an issue with quorum, they may get rescheduled. People leave agencies, people have rulemaking coordinators and staff that are key to the process may have things that take them out of the office. So it's really important to just don't rely on that as a possibility. If you make the request and it happens for you, that's great. But don't count on it. Historically, over the past quite a few years, that's just not something that the commission has chosen, a power they've chosen to exercise.
And I would sum up what Anna just said as setting the schedule for readoption of your rules may be one of the most important things you do for your agency. About half of us have already been through the process of step one that Anna is going to go over briefly for the folks among us who are new to this, and about half still have to work with RRC and get through the first parts of the process. Most of today we're going to talk about the readoption, the actual once you get through those first 2 or 3 steps and you start negotiating and setting a schedule for when you have to readopt your rules. But for all the reasons Anna just said, this is one of the most important things you can do for your agency and for your successors if you're planning to retire soon. But don't just think of it the way most of us usually think of rulemaking as, oh God, we got to do that again. This is a process that can actually be a huge benefit to your organization. Convince your staff, which is hard to do when you're dealing with rulemaking, and they don't do it very often, that this is an opportunity. We just went through 3 years of redoing our notary rules, and what you inevitably learn when rules haven't been looked at, and rules were all created at once in 2007. What you inevitably learn is there have been changes in the way things have been done. There are changes in policies and procedures that may not have been incorporated yet into your rules. There may have been changes in case law or other agencies' rules and laws that you need to integrate into yours. There may be changes in technology. Your rules may only address paper filing and now need to address e-filing. There are definitely instances in which you need to be using this as an opportunity to update things like names of organizations that have changed. So that's that our overall goal is to convince you by the end of this, if you haven't already set your schedule, this is something that you need to convince your agency is really important. And we'll talk about the kinds of things to consider after Anna summarizes the process for folks.
Thanks, Anne. And I just want to chime in on that. When you go through the readoption phase, you can certainly amend the rule, and that's what Anne was getting at. Recognize this is an opportunity if your agency is required to use U.S. mail and it would be more efficient and you capture electronic mail, email addresses, this is a great time to make that change. So the first step in what we call the periodic review and expiration of existing rules process is the easy step. And that is the designation of the rules. And again, for those of you that were around a few years ago for the process, we had 3 buckets. We all know we had what I call the necessary with, necessary without, and unnecessary. In this process, there is no middle bucket. The rules have to be identified and categorized as either necessary or unnecessary. So know that that is a significant difference. You also want to go ahead, and if you aren't sure and haven't already done this, and let me just kind of jump ahead and then I'll jump back. You will receive the agency that's responsible for the rulemaking coordinator will receive an Excel spreadsheet just like before from the rules review staff. So if you haven't received that yet, then you're probably off a good ways. You've got some breathing room. But
Anna, I'm going to interrupt just a second and
sure.
say, when you get that, one of the things to check for is, do they have the right agency? Given how much reorganization there's been in state government, it's possible that OAH hasn't isn't aware of a change and you're not actually responsible for rules. Let them know that immediately.
That's a good point. And again, we don't aren't privy to how they're drawing on this information. If they're relying on the agencies from the last go round, or if it's been a very recent change that may not pop up on their radar. If you get it and your agency's not responsible for that rule or for those rules, let them know. But what I was going to say is that if you haven't gotten it and you know that you're kind of way down the road, do take a look on the rules reviews page. There's lots of great information, but there is a schedule where your agency is. So if you don't know, I would encourage you by the end of the day, go and figure that out. And if you still can't find it, you are welcome to reach out to me and Ann, and we can point you in the right direction. And so prior to that date, I would say several months before that date, Rules Review is going to send you a spreadsheet. And what you're going to need to do, what your agency is going to need to do, is to categorize. And I would absolutely encourage staff. When I say staff, it could be a rulemaking coordinator, it could be counsel, could be someone else that works in rules. Absolutely make recommendations. If there are some rules that, the staff believes it's just not necessary anymore, certainly bring that up. It may be that you don't need that rule, and that's one less rule to worry about. And when it comes to making that categorization, um, my preference is to encourage the agency rulemaking body to actually vote on those categories for the spreadsheet. Though, Anne, is that technically required?
No, I think there's probably mixed opinion about that. It's a protective measure for yourself to have that in the record in your minutes. And for agencies, we get Secretary Marshall here at Secretary of State, we get the head of the agency to sign off something approving um, the categorizations and submission publication, and then again, if we've changed anything before we actually submit it to RRC.
Okay. And I also want to point out that Kyle just put the link to the OAH webpage with the periodic review schedule in the chat. So I would encourage, if you aren't familiar with when your deadline is for this step one, go check that out today. So when you get the spreadsheet, I would say that it's dummy proof, but I can speak. I've even forgotten to click on some of those drop downs. So they do make it as easy as they can for you, just saying, what category is it? But double check. Make sure you're not skipping a row. Absolutely make sure you're not skipping a wrong category. Their email will tell you exactly what you need to do with this spreadsheet. And so just get it back to them, per their directions so they can post it on the OAH website. Keep in mind that the agency must also post it on the agency's website and invite public comment. And I believe there was recently a rulemaking issue about where something was posted on the agency, whether it was on the agency down here or the larger umbrella agency's website. I would encourage you to post it exactly on the rulemaking agency's website. And note that very similar to permanent rulemaking, you have to accept comments for 60 days. And that's the purpose of this.
And I would add, make sure that you alert whoever does your IT and your website that it's coming and that it's statutorily required. Because if you mess up your deadlines, you're pushing your whole timeline back.
Absolutely. We've got a couple of comments that I'm going to touch on in just a second, but I just want to finish up talking about step one. So after you've got the 60-day comment period, so again, think about your timeline. You submit the report to Rules Review. Again, you submit it spreadsheet, you follow their directions. So in my opinion, if there's no, and I say my opinion, and I think that I have also, in my interpretation, and again, this is just mine, just Anna, not speaking for anybody else, is that if there's no change to the initial determination, there's no, especially if there's no comment, there's no need for the rulemaking body to vote again. However, I'm seeing a couple of comments here. Let's see, where someone has asked, was told that approval by the rulemaking body was mandatory both before and after the public comment period, even though we deemed all rules necessary. That is not my interpretation, but I had a law partner that had a great saying, sometimes you want to have belt and suspenders. So there is nothing wrong with having your rulemaking body vote to designate and then vote, even if there have been no comments, that is what we are going to submit. But Anne, is it your understanding that is absolute, is not an absolute requirement?
I think that's true. I think
Okay.
you're doing it to make sure, first, to make sure that your agency head, board, or commission know what you're doing and agree with it. You're not stepping outside your parameters. And secondly, you document it for the record.
Okay. Kyle has also got a comment that says Rules Review staff attorneys have previously indicated to me that the rulemaking agency must make an initial determination and the final determination regarding the necessity. That is not specifically what the statute says. However, what they're telling you is they're giving you the bulletproof information. If your agency votes at the beginning and votes after the 60 days, nobody can say that you didn't follow the process. And we all know that sometimes we have a conflict as to interpretations with agency counsel or private counsel and rules review counsel. I mean, lawyers, and it's shocking, but lawyers have a difference of opinions. So what we're telling you is what the statute says, but it's going to be bulletproof if your agency votes at the beginning and votes at the end. So talk to your attorney if you're the rulemaking coordinator, and do what your attorney feels is best. So that is all that we were going to talk about regarding step one, which is just that designation.
I would say one other thing about step one, and that is, especially if you're new to this, it's easy to get confused and think that the deadline that's on the schedule that Anna referred to earlier, that's on the website, that's actually when you have to submit it to RRC, and it's always 1 month before. So if your deadline is October 2025, you have to submit it to your approved scheduled to your approved categorizations to RRC by the 20th of August.
And I would say that the 20th is typically the deadline. Always check in the prior month if that date falls on a weekend or a holiday.
Nope. I've got an email from RRC Anna that says they do not follow the rules of civil procedure in that
I
regard.
know that that's what I was going to say. Make sure if it falls on a weekend, I would encourage you to submit it on the Friday before to just get it in. So then the next step of the process is what we'll kind of combine is step 2 and 3. So basically you've gotten the Excel spreadsheet from Rules Review. You've looked it over. Those are your rules. Your agency has determined whether they're necessary or unnecessary. You've had the 60-day comment period. Your agency's like, yep, we're sticking with that. You submit it to Rules Review. Rules Review receives that report. And keep in mind that the statute allows, like if you have designated a rule as unnecessary, the Rules Review Commission can actually elevate it back to necessary. They have that discretion. Do we know of any circumstances that they've done that, Ann?
Not this round that I'm aware of.
Okay. And so sometimes folks are like, okay, well, when does that unnecessary rule disappear? Well, it expires on the first day of the month following the date that the report becomes effective. So your report becomes effective typically, look at the statute, but typically the 61st day after the Joint Legislative APO receives the report from RRC. So it's not like permanent rulemaking where it happens the first of the following month. They actually take that report, they send it to APO, and then typically, again, look at the statute, there's some nuance there, it's the 61st day. So that's going to matter for your unnecessary rules. So that's sort of what I'll call sort of the step 2 and 3. And so then we start talking about readoption, which is hard in that it's going to be a lot of work because we're talking about complete sets of agencies' rules. And so after step 1, what's going to happen is Rules Review is going to reach back out to the rulemaking coordinator. Again, they're going to reach out to provide some guidance, and they're going to propose an agency timetable. And my experience is they are typically proposing a timetable that is about 2 years out. In other words, they're saying, okay, we've got your designations, your report's been approved, it's time for you to start the permanent rulemaking process, and you've got 2 years to basically start and finish it. So, Anne, what are your thoughts?
They've actually said that's going to be their standard is 2 years from that date. The second takeaway, besides how important this is to all of us, rather, that we would like you to take from this is do not just accept the date that they give you. They're giving you a date based on, I'm going to read a quote from them from one of their emails. We are attempting to spread the rules out as much as possible while doing our best to accommodate the needs and priorities of each agency. We do have a PowerPoint that I may or may not show depending on how we have time. If we don't actually end up using it, we'll send it out to you. What it has, the first part is quotes from staff emails that are published on the OAH website. And then the second half is extracts from people's actual proposed schedules that they're proposing to RRC. Anna's way of summarizing what we're going to talk about right now is give yourself a cushion. A big cushion would be my addition to that. Anna, you want to talk about working backwards?
Sure. And I would say for some of you, 2 years may be fine. It may be, if your rulemaking body meets, quarterly or even more frequently, and you don't have a lot of rules, and I think this is important, they've been, what I would say, they've been touched within the past 5 years, it's probably not going to be, 2 years is probably fine. But give yourself a cushion. And what I would say is figure out when you need to start by looking at the end date. The final date that they will give you is not the date. Typically, we're always thinking about the date that we have to file at RRC at the end of the process. That's not what it is in this process. That final date, and this is in paragraph D2 of the statute, is the date by which the agency must readopt the rules. So again, that it's before you would file it with RRC. So just know that. So that date by which the agency must readopt the rules would be the date of an agency vote or an agency decision. So if your agency is nimble and loves, does virtual meetings sometime, then you know that your agency is flexible. But if you've got a meeting where it's always, always, always in-person meeting, don't push up against the meeting that's the month before what the deadline is. Try to pick a quarterly meeting that maybe is 6 months before that, if not earlier. And again, this is a perfect time to just remind everybody that Rules Review has been very transparent about their preference not to grant extensions of time. So don't count on that. But again, like I said, 2 years may be fine. I even one time for a smaller agency asked to do it in less than 2 years, and they were like, no. So I think to Ann's point, that 2 years is kind of their middle ground. But I think Ann would certainly say that if your agency has a lot of rules, if they're complicated, if they're lengthy, if they haven't been touched in a long time, definitely, explain and communicate it. Explain why you're asking for more.
And what we're going to talk about now is exactly those kinds of things. I will quickly answer. Someone asked in the chat, what's the longest time you've known to give them? And I am going to switch and share, assuming that I can find there. I can't do two things at once. There we go. This is our schedule for the Secretary of State. And one of the things we're going to be talking about now, and you'll see we've asked for December 31, 2034 for one set of rules. That's our securities rules. We've actually proposed and given them the years for all of our rules. And when we get into the PowerPoint, you'll see that there are several other bigger agencies that are essentially laying out their, even if they're not going into the details, they're laying out their schedules for all of their rules. With our securities rules, I can tell you that they are uniform laws, which means we have to be in harmony with other states' Uniform Securities Act. They're affected by federal law, and the Trump administration has announced that it may, for example, redefine certain cryptocurrency things as not being securities. And so there's a lot going on changing federal law that, and our rules are old. And so we know that they're going to need a lot of work.
And has Rules Review approved that 2034 date?
Yes,
Okay.
it was approved at the April meeting.
Okay, so we've got a question about what is the longest time we've known to approve them. I mean, right there, that's 9 years out in the future. One of the other questions was, and I think that just ties into what Ann just said, what factors should an agency articulate? I'm
Okay.
don't mean to interrupt Ann, but I think, just what she said, if there's federal law that impacts this, if there's change, other stakeholders, other agencies, tell them that. Tell them that.
And I am now going to share the PowerPoint. Where what I have done is I have gone through and I have selected and I can't see it, but Anna, can you all see it?
I see sample language,
Yeah, okay.
EMC and SBI DPS.
Yes. Okay. Let me go back to the beginning and quickly through. I read you the comment from them that the staff is trying to spread it out. And remember when you're dealing with these schedules that they have a very small staff and they're going to be reviewing thousands of rules and they don't get a break to stop reviewing all of our new rules as we come along and all of our amendments as we come along over the next 10 years. Important to know, they're going to, whatever date you give them, they're going to move it to the first of the month, just for their administrative purposes. They do expect, and their rules and the statute require a breakdown of essentially the critical formal steps in permanent rulemaking. They have not seemed to be super particular about requiring every single paragraph of permanent rulemaking statute be in your schedule. Let's see, they're trying to spread it out. Sorry, it is not letting me move. Timelines can be projected. They told somebody in one of their emails, and I've put TW is Travis, and some of these have S, that's Seth. I've put the date of the email to help you find it if you need it. But this one was of interest and use. Circumstances may change and unforeseeable events may arise. So communicate if you have it, if something changes. And the example that I would give all of us right now is that there is a bill in the General Assembly that moved out of committee this week and went to Senate Rules yesterday, and I have not followed up to see what happened to it. That would change the fiscal note requirements and potentially require a lot more of us to do fiscal notes. It would be, instead of 1 million in 1 year, it would be, I think, 1 million in 5 years for all affected parties. And that would have a substantial effect. That's the kind of thing, if that bill were enacted and the governor signs it or they override a veto, then those of you who have already been through the process and set your schedule should go back and look at it and consider changes. They list several factors in response to the question that Anna read. You have to, once you readopt, which is the date on the schedule, you have to submit it to RRC within 30 days. That's not in the APA itself. That's actually in the RRC rules.
And I just want to mention, Elizabeth Pope just put in the chat that Senate Finance voted favorably for that bill yesterday.
Okay.
So it's still moving along.
You have to consider fiscal notes and amendments. And then they've got some other comments, but I wanted to share some of the things that agencies are actually putting in their
explanations for the.
Can you see the one from EMC now?
Yes, it says EMC rules are part of the federally required triennial review.
Yeah, and they're one of the agencies that proposed essentially their complete schedule all at once, even though not all of their rules had been through the categorization process. They thought ahead. And then another one that Anna mentioned, the SBI DPS one that has been through so far, they actually told RRC, hey, wait a minute, this agency's moved. but we're going to work together to try and do it, and we've come up with a proposed schedule out of that.
And that wasn't a problem for rules review staff, correct? Or do we know?
No, I believe they've approved all the schedules in some form. Staff is sometimes coming back and saying, well, wait a minute, we've already got 200 rules that month. I'm going to move you from September to October. Or you asked for this month, can we go back a month earlier? So pay close attention to the emails you get from them.
Right. And it sounds like, and I think my experience is kind of circling back, they're offering a proposal for a schedule for 2 years. That may work beautifully for your agency, or there may be reasons, as Anne has highlighted, for the Secretary of State's office that just doesn't work for some of her rules. And so it's all about communication. I see, Anne, we've gotten a question. Someone asked, do you have to submit all rules for readoption at one time? No, I think Anne's schedule reflected that, but that's part of the communication that you want to have. If you've got different subchapters of rules, this is how you want to handle this, or this is how you want to handle that.
If the questioner is asking is, like, if you've got a subchapter that's scheduled for, take our securities rules, December 2034, do you have to submit the whole readoption at one time? My understanding from our RRC staff is yes, they expect that entire package to be submitted at one time. But we might amend some of those rules in between. And that what you would do there is you would make sure that our RRC staff knows it. If what you're asking is, can you readopt that subchapter and submit some of the readopted rules in January and submit some of them in February and some of them and then by your deadline of September, whatever year, have submitted them all. My understanding of something that one of the staff said in one of their staff meetings was that you can do that, but they may not consider them because they're setting a schedule based on their time.
They won't consider them early.
Yeah.
Okay.
I think you can ask for them to be considered early, but I would not. It's kind of the reverse of Anna's discussion about asking for extensions.
Yeah, I think I actually did that the last go round. There were some that we just submitted early just because we could, and we just kind of wanted to get it done with. And review was like, thanks. This is when we're going to review it. And we were like, fine. That is perfectly fine. We just want you to have it. So there's nothing wrong about doing.
And the only thing about that is do take into account if you have that conversation with them, you're probably going to have to change your effective date, or you may have to.
Sure.
What I've got on screen now is the kinds of language that I found that people are submitting, and I'm sorry. One that boards like Anna's been talking about, since that's primarily what she represents these days. There's common language across a number of the boards and commissions. Be clear, you're not talking about a specific date. None of us can talk about a specific date right now, other than the staff saying they're setting everything for the first of the month. And the reason is because, among other things, the Codifier of Rules has not published this publication schedule for that far in advance. Typically, the publication schedule is only 1 year in advance. And the other thing Anna mentioned about meeting dates, you see that the AG included that, and they built in, she said, cushion, they built in for extra meetings. Consider that the membership of your board or commission, if that's what you're dealing with, may change, and you may end up in one of those situations where there's disagreement and they don't like the rules that you've drafted if there are changes. So build in some cushion for that.
And I kind of want to, I'm just keeping an eye on the time. We've got about 20 more minutes. And I think I just kind of want to take us back to, and I think it's good to have this sample language here. And as we talk, I think people can see it. But I think the takeaway here is when you are working on your readoption schedule, and someone has asked, is the readoption deadline established by agreement between the rulemaking agency and RRC staff? And is that the deadline by which the agency must make its initial adoption? No, it is after the final after the comment period ends. So just because you've got this comment period, you've got meetings that may or may not happen on time. You've got, I mean, I was on Rules Review Commission during the last process, and so I saw agencies that had to come and ask for more time because so-and-so left, so-and-so was in the hospital, build in for that. And as Ann said, fiscal notes right now, paragraph D2 says that it is not required, that they will not be required if the rule is readopted without substantive change, or if the rule is amended to impose a less stringent burden on regulated persons. But again, we've got a bill that might impact that.
Even barring that, my recommendation to people who ask about fiscal notes, and I know we've already had some requests for one of these rules of the road to deal with fiscal notes, given that there's a bill that's got at least moving in the General Assembly. I don't think we're likely to do one on fiscal notes soon. I always do what I call a no fiscal note, so that I've got an email in the file from Julie at OSBM or her predecessor that says a fiscal note is not needed for these rules. And what I do is I follow the state budget manual requirements for a fiscal note in that, and I attach the rule and I explain, this rule really is codifying a procedure everybody's known for 10 years, and it doesn't add any expenses. It may actually save some since it's electronic or whatever. I don't think I've ever had a no fiscal note that was longer than 2 or 3 pages, maybe. But it's worth it to have that email in the file that says you don't have to do a fiscal note. But so you want to consider factors like, do you have one of those statutes that has a provision that says, to the extent possible, you shall harmonize with other states? Do you have an interstate compact you have to deal with? Are there federal laws and regs? Are there uniform or model laws you have to consider? Or federal or international standards, including those that you've incorporated by reference in your rules, like NIST and NFPA and ISO? If yes, when was the last time somebody did research to make sure you're up to date with them? When was the last time that you actually had somebody sit down with a subchapter of your rules and read it start to finish and look at it and think? One of our recommendations is, hey, if you've got one of those dates that's 5 years out when you negotiate with a date with RRC, use that time. Make sure you've got somebody who's very familiar with the style guide. Jerry Cohen wrote it. He was the bill drafting head in the legislature for 30 years or more, and all of us had the opportunity to comment on it. That way you will have fewer technical corrections and you will make RRC staff less angry.
So, Ann, let me make sure, just to kind of rephrase what you're saying so that we can help the folks that are listening. So there is, what Ann's saying is there is a style guide. And so is it your suggestion that if an agency has a rule that it feels that the content is fine, but the formatting is not in accordance with the style guide, that your recommendation would be to when you start the readoption process, to start it with a rule that is formatted per the style guide so that there's less work to do on the back end. Is that your suggestion?
Well, yes, except that the style guide, people think it's about formatting. There's some formatting in it, but mostly it's about word choice. Basic, there are some basic rules that when you've been around doing rulemaking for a year, and this isn't just the current crew of staff. It goes back to Bobby and Joe, the original sort of crew who did this kind of thing. Um, there are words that you should just not use, and it's hard to convince your experts because we all use them in everyday conversation. Words that end in ly end badly for you when staff is reviewing your rules, unless you've explained it adequately.
So, Anne, what I guess again, I want us to kind of want to make sure that we're providing guidance, especially for folks that aren't quite in it up to their necks like you and I are. So, is your suggestion to try as best you can to get the agency to file an cleaned up as best as possible rule with the notice of text, which starts, okay, okay.
And one thing I guess we should make clear that I even sometimes get confused about, we are talking about readoption. The truth is, once you negotiate your date for readoption, from that point forward, when RRC has actually approved the staff recommendation for a date, just start thinking about it as adoption. Because really what you're doing is you're adopting permanent rules with or without changes. And what you've got to pay attention to is all the steps in the requirements for permanent rulemaking.
And tagging in on that, Anne, I'd like to just briefly mention rulemaking hearings.
Yes.
Rulemaking hearings, again, typical, just standard permanent rulemaking process, which is really what we're talking about, is not required. They are not required unless requested. And so my practice tip, Anna's humble opinion, is anytime you are running a rule through the permanent rulemaking process, which all of these rules will be running through the permanent rulemaking process, have a public hearing. Do it, because you don't want to be called on it at the end, and then you've got to go back, and then you've blown your deadline.
Yeah.
For those of you that don't do rulemaking much, or that don't, just don't do it much, your permanent, your rulemaking hearing does not have to be in front of the agency. It can be a staff person. It's certainly, especially if you feel that there's not going to be any comments. I mean, if it's something where there's going to be a ton of comments, it's good to have it in front of the agency, the rulemaking body that makes those decisions. But if it's just a pro forma, want to check it off, it can be a staff person, record it, and then you've got a recording that there were no public comments, and you've had your staff, you've got your public hearing.
And Anna and I have talked about putting rulemaking hearings on the list for some future one of these. It doesn't, if you don't expect any public comment at all, it doesn't have to be long. But I mean, I've had a, what some people don't know is the legislative calendars, or actually the News and Observer's legislative dealie, often at the bottom has other public hearings. And I've actually had a citizen who had nothing to do with it walk into a public hearing that we scheduled for 15 minutes. And he showed up and said, I'm just curious about government. But it does save you time in the end if you go on and hold that public hearing.
And we've gotten a question about whether they have to be recorded or by a court reporter. And Kyle said they record theirs never without a court reporter. Either is fine. Just keep in mind that if you are having the public hearing and it's not in front of the rulemaking body and you expect comments, you need to find a way to get that information to the rulemaking body. In other words, I'm just going to use the General Contractors Board as an example. If I were to schedule a public hearing on a day that they're not meeting, and I know that there's not going to be anybody here to say anything, that's fine. I've still got a recording, and you should maintain the recording, and you need to maintain that recording. But if there's going to be if I know there's going to be a lot of public comment, then I may want to have that whatever I record transcribed or have a court reporter so that I can distribute that to the board members, because that's the whole purpose of a public hearing, to receive comments. They need to get whatever the public hearing comments are. They need to see that. They need to see the written ones before they have that second vote to adopt the rules. So good question. Good question. Either is fine, but just know that if they're comments, you got to find a way.
Ann and Anna, I'm going to jump in just for a second. We got about 10 minutes left. So if you have questions, please start dropping those in the chat. I want to give Ann and Anna a couple minutes to give some final thoughts, wrap up where they want, and I will continue to look for questions.
One
Thanks,
of the
Rob.
things to the person who asked about factors to build in, and you can see other agencies' letters. Mine was about 7 pages. And it's on the April in the you can always go back, and where I found all these things that you're seeing in the PowerPoint is on the RRC's website. Down at the right, there is an archive, and you can see the minutes for every meeting, what rules were approved, but you can also actually see the agenda and all the stuff that they have posted there. And that's where I found the stuff that I've been putting on here. One of the things that Anna and I talked about is if you think there's a chance you're going to need a pre-review for statutory rulemaking authority, for example, does RRC staff see a problem? Go on and ask for pre-review early on.
And let me stop you and just say, because we have a lot of people on here whose names I don't recognize.
Okay.
Does anybody not know what we mean when we say pre-review? If you don't, we'll just kind of watch the chat. Ann will
Raise your hand.
Yeah, raise your hand. Also, Ann, you are sharing our outline. Are you aware of that?
Nope, I'm not.
Okay.
Let me.
I didn't think so. There we go.
Sorry
Okay,
about
so
that.
we have at least one person that doesn't, and I appreciate you speaking up. Do you want to explain what?
Yeah.
So pre-review is absolute. I will start off by saying it is not in statute at all. It is a courtesy process, courtesy service that Rules Review provides. So, Ann, before you talk about pre-review, tell them what a pre-review is.
Okay, pre-review is generally it's when you've got some rules written and you're not sure about them. You know, your staff or your board are really insistent we need to do this and say this, and you may think that you don't have the authority to do it based on your statute's authority provisions for rulemaking. Or you may just think this may be a problem at RRC, maybe there's a way to fix it. You can submit those draft rules to RRC staff attorneys and they will review them because we're going to be readopting the whole administrative code basically. I would
let me stop you. I would hesitate to say they will review them because I know at times they've been overwhelmed with other stuff, and again, because it's not a statutory obligation, they do them when they can. So I think in a nutshell, it is an opportunity to have rules review staff review your rules, sort of what I would call off the record, to look at it and identify things that need to be cleaned up, and especially things that could lead to an objection because those, if you can fix, you want to, so that maybe you can then, when you start the formal permanent rulemaking process, you can incorporate those and you have less to clean up at the end of the process. But it's not something they're always offering. It can take months at a time because, again, they're doing it. It is not a priority, nor do we expect them to make it a priority.
In fact, one of the staff has indicated that he would think that anybody that's incorporating, and I can't remember exactly the comment, so I'm not quoting him, but he basically seemed to be saying, if you're going to ask for pre-review, build in 6 months minimum.
Yeah, and I think that's,
that.
yeah, and it depends on the rule too, but it's very helpful because, again, if your rule is a rule that you think you've got statutory authority, but you know that some might, and so you've got this informal, totally off the record comment by a review of the staff, and they're like, I would question this with statutory authority. You need to know that on the front end so your agency can deal with it before the end of the process.
Yeah, you may want to go get a legislative change.
So, and we've got 4 more minutes, and so
One
I'll
thing I
let
want
you
to say
close
real
up.
quickly is keep records of your pre-review stuff. And even if you just send staff an email and say, can I actually say this? Somebody wants that. Keep those records. Our friend Jeff Gray, former section chair, has told a story about going back into his predecessor's records and finding a record where a staff member had told him, yes, you can do this, when a current staff member was saying, no, you couldn't. And he was able to go back in the files and find that and use it. So keep records of those contacts.
So, Anne, is there anything else you wanted to touch base on? You mentioned pre-review, and we talked about
Exemptions.
fiscal note.
Exemptions, what we're talking about with exemptions is exemption from the entirety of the readoption process and all those 3 steps that Anna went through. We managed to get it for our notary rules, but that's because we were actually rewriting all of the notary rules, and they would not give us the exemption until we actually were in the formal rulemaking process, so they could be guaranteed we weren't just trying to get out of it. It is going to be rare that they will give you an exemption.
Someone has asked, oh, good, Rob's already answered it, about sharing the recording. Someone has asked, for public hearings, is it advised to address multiple unrelated rules from various subchapters? I think it depends on, I think it depends on the rules. I think there's no reason that you can't do them all, but I think, again, look at your agency's collective body of rules. If you've got 300 rules and they just cover the gambit, you may not want, and there's going to be a lot of comments, you may not want to do them all at one time. If you're an occupational licensing board or a very small rulemaking body, maybe that has, 50 or 75 rules, and there might be, a couple of subchapters, but you're not going to get a lot of comments. There's nothing wrong with that.
There's a question, is it permissible to completely delete the text of a rule in readoption and replace it with something else? I would talk with Brian, who is the codifier of rules, but we actually did do that. There are instances when it's allowed and instances when it's not. We actually have the former publisher of the rules, who was also expert on that, as a member of this group now. She's now the coordinator, I think, for the Industrial Commission. There are times when they will let you do that. The other thing to consider in your readoptions is think about reorganizing your rules and moving things around. And if it would be easier, and think about Bobby and Joe's advice way back when to all of us was keep your rules short. If you have long rules that address one rule that addresses multiple topics, consider breaking each one into a separate rule. And the reason is that RRC can always address, if you go back and amend it, and you're only amending or repealing paragraph B, RRC can look at it all.
Mm-hmm.
And sometimes it's easier for your audience, your regulated community, if each topic is a separate paragraph too, separate rule.
All right.
Somebody pointed out there's a requirement for those of you that aren't paying attention to the chat and the questions. There is a pre-review cover sheet that you have to fill out, and you have to certify that you've checked, do you have statutory authority and things like that. We all know about it because the administrative law section wrote the first draft of that form for RRC. All
right. That brings us to the end of our time. I want to say a huge thank you to Ann Wall and Anna Barrett-Choi. This was a fantastic program, a tremendous amount of information. As you can tell, we could probably spend a couple hours here going through everything, but that's why this is going to be a series. This is not our only edition. This will be every other month. So we do encourage you to take the survey. We'll send that out. Please give us your feedback on the content from today. Do you have any outstanding questions? Also, what do you want to hear about in the future? We're talking about covering the basics of rulemaking. We can cover pre-review more in depth. There's a wealth of information to go over, so please fill out that survey because this is for you. The video link and the PowerPoint, we can send those out so you have that information. Shameless plug again, if you are a member, please join the section. Or if you're not a member, join the section. I can't speak enough about the benefits that this section provides. It has been an important part of my development and my career. If you are a member and want to be more involved, please contact Brianche, our section manager, Frank Trainer, our incoming chair, or myself about becoming more involved. There's a multitude of ways to be involved in our section, whether it is in being on a committee chair, planning the CLE, posting articles to the blog. Please get involved. All right. Thank you.
I'd like to say one thing,
Ann,
which is thank you to the people who submitted questions, and especially to those of you who answered questions.
All right. Thanks, everyone. Have a great weekend.